Okay, good afternoon, everyone. I think we'll get started because we have an incredibly interesting speaker today, and we want to have time to have a conversation afterwards. So we need to get started to make sure that we have time for that. So it's my great pleasure to introduce to you one of the 25 most influential lawyers in Canada for 2014, and a graduate of this law school, class of 1982. Edgar Schmidt was recognized this year by Canadian Lawyer magazine as one of the 25 most influential lawyers in Canada. And here's what they said about how they decide, or what is signified by that. They said that these are lawyers who've been influential within the profession and in society, and inclusion in the top 25 talks to a level of respect, the ability to influence public opinion and to help shape the laws of this country and others, to strengthen or to contribute to the strength and quality of legal services, as well as to access to justice and social and political influence and involvement. I would add that in Edgar's case, it also speaks to courage, integrity, intellect, and a deep devotion to the public interest. Well, it seems that probably I'm not alone in that assessment, because back in 1982, his classmates in the yearbook, watch out guys, because these things are great sources. His classmates may have had a bit of a clue about some of these attributes. Here's how they described him in his graduating year. In Edgar's quest for legal knowledge, he picked up many details the rest of us glossed over as unimportant. We appreciate his taking the time out in class to point them out. That impish grin on his face means it's only a matter of time before he has politely destroyed his opponent's legal argument. May I say, hear, hear. We're thrilled to have Edgar Schmidt with us today to bring us some of that attention to detail, because he's going to talk to you about statutory interpretation, and also to help us understand the foundation for the ethical choices that he was faced with and the legal arguments that he'll be making in the case that is, at least on a motion, going before the court this coming Monday. You couldn't get it hotter off the press than this. Please join me in welcoming Edgar Schmidt.
Thank you. The mic is working, I trust? You can hear me? Okay. Thank you for those kind words of introduction. I was surprised to when you pointed out this description to me. Reminded me of it. I'd long since forgotten it, but it reminded me of one other report card type comment. When I was in grade 7, I believe it was, I brought home a report card, and the comment from the teacher said, "Edgar is a good student, but he is too outspoken sometimes." And I had to have my father explain to me what that meant. So I hope that over the course of my life became at least somewhat useful and not only annoying to people. So I want to talk to you really about two things. I want to tell you just a story. I want to tell you, how did I come to sue my own minister and deputy minister? And then look a little bit at legislative interpretation. I don't know how many of you may actually be familiar with that song. What's love got to do with it, got to do with it? Well, it's what's legislative interpretation got to do with it today. So let's start with the cautionary tale. Wikipedia says a cautionary tale has 3 essential parts. And of course, Wikipedia is your prime go-to source, right? Research source. I'm sure your professors would say so, right? First, a taboo or prohibition is stated. Some act, location, or thing is said to be dangerous. Then the narrative is told. Someone disregarded the warning, performing the forbidden act, and finally the violator comes to an unpleasant fate, frequently related in expansive and grisly detail. Well, you'll note that I put a question mark after the cautionary tale. You can sort out for yourselves whether it's a cautionary tale or not. So, how did I come to sue my own minister and deputy minister? Well, I was in the public service. I was employed in the Department of Justice in Ottawa. I'd been employed there since 1998. The first year and a bit I worked in the legal services unit that was attached to the Department of Indian Affairs and Northern Development, as it was then called. It has a new name, which I forget. Then shortly thereafter, in 1999, I made the move to the Legislative Services Branch, which is a central group that drafts the bills that the government will introduce in Parliament, as well as regulations that are made by state actors. Generally the Governor and Council, but sometimes ministers, sometimes other organizations or agencies. I wanted that particular role because I had done a graduate program in the University of Ottawa in legislative drafting, and felt this was something that really appealed to me, the idea of translating policy into words, into text that would hopefully implement that policy and avoid implementing all sorts of unintended things, avoid unintended consequences to the extent possible, and so on. I thought that sort of chess game interested me and would be fun. So here I was in the public service. Well, what does that mean? What's the framework? What's the context in which I was located? And in my view, I think you have to think about the Canadian Constitution. It was useful for me to think about the Canadian Bill of Rights because it has a certain, I think they refer to it generally as quasi-constitutional status, in that it's intended to take precedence over legislation unless other legislation expressly says it operates notwithstanding the Bill of Rights. Then there were also various regulation-making powers in various acts. So when we would be reviewing or drafting a regulation, we would have to consider the essential question of, is this regulation, what I am proposing in this text, is it authorized? Because, as you will soon know if you do not already, agents and others who act out of delegated or given authority, generally speaking, have a duty to act within that authority. They are not free to simply do whatever they feel like doing and saying, oh, this is good. Let my principal, if it's an agency relationship, get on my case if he or she doesn't like what I'm doing, but in the meantime, I'm just going to do what I feel like doing. That would generally not be considered appropriate conduct for someone acting out of delegated powers. Then there were three particular examination provisions that were relevant, and we're going to look at each of them. They were particularly relevant to me for a while because in 2002, my boss at the time said, well, one of your colleagues has been doing this work of examining bills for the entire branch for several years now. I'd like to relieve him of that job and give it to you. Would you be willing to act as the examiner of bills under Section 3 of the Canadian Bill of Rights and Section 4.1 of the Department of Justice Act? And I said, yeah, I think I'd be willing to do that. So, of course, I had to read those sections. Now, I was aware in a general way that they existed, but I hadn't looked at them carefully and closely because up to then it hadn't been part of my own personal responsibilities. So, I looked at them. Okay, so let's move on and see a little bit about what they said. Before the Bill of Rights was enacted in 1960, an earlier version was presented to Parliament. This was in 1958, and it was Bill C-60. And I want you to note, in particular, the underlined words. So the Minister of Justice is being directed to examine every proposed regulation and every bill to ensure that the purposes and provisions of this part, which was the Canadian Bill of Rights, in relation thereto are fully carried out. When the bill was reintroduced and then eventually enacted in 1960, that wording had been modified. It was modified to say that the examination was to be conducted in order to ascertain whether any of the provisions thereof are inconsistent with the purposes and provisions of the Bill of Rights. And it went on to say, and the minister shall report any such inconsistency at the first convenient opportunity to the House of Commons. Okay. Now, in the House of Commons, before the committee that was studying this bill, before it was enacted, in the process of it being enacted, the Minister of Justice commented on the first change, the change there from to ensure the purposes were carried out to in order to ascertain whether there's any inconsistency. And he said, well, when we thought about it a little more, we were unsure whether ensure was an appropriate word, because it seems to suggest that the Minister of Justice had a certain power to effect this result. And the Minister of Justice said, well, but he's supposed to be reviewing both government bills and private members' bills. How can the Minister of Justice control what a private member introduces into the House? That's inappropriate. First of all, he doesn't have, objectively, that power. And secondly, it wouldn't really be appropriate for him to have it. And he said, even within the government, he said, is it really appropriate for the Minister of Justice to dictate to his or her colleagues in cabinet what they may introduce or not introduce? So he said, we've revised this to say that he has to examine them in order to ascertain and provide information to Parliament so that Parliament can make an informed decision. So that was what the Minister of Justice said, around 1960, when this bill was being studied in the House of Commons. Later on, when the Statutory Instruments Act was enacted in 1972, they narrowed or changed the application of this examination provision to refer to, instead of proposed regulations, to refer to regulations transmitted for registration. In other words, ones that had been made. And the Minister of Justice at the time, the Ministers of Justice, incidentally, for these three provisions are quite high-profile ministers. The first one was E. Davy Fulton. The second one, John N. Turner, later on Prime Minister, was Minister of Justice who introduced the Statutory Instruments Act provision, and he explained the reason for this change to made regulations from proposed regulations. And he said, well, under this new Statutory Instruments Act regime, you're going to be examining proposed regulations under that regime, and then this provision is simply to allow for certification of conformity. So he said the proposed examination, which will be conducted by the Deputy Minister, will identify and resolve any issues, and then the Minister of Justice can certify conformity in the actual regulation as made. Okay. A further change happened in 1985, where they first of all made it only applicable to government bills. Up to then, it had been applicable to private members' bills introduced by a private member, as well as bills introduced by the government, by a minister of the Crown. So it was narrowed in application to government bills, and then they added this exception in subsection 2, which says that a regulation doesn't even need to be examined under subsection 1 if, before it was made, it was examined as a proposed regulation under the Statutory Instruments Act to ensure that it was not inconsistent with the purposes and provisions of this part. I think I've already commented largely on this. I simply want to indicate that the then Minister of Justice indicated that it would be his duty under this provision to see that a bill conforms to, pardon me, I zipped ahead too fast here, conforms to the Bill of Rights. That was what his description was of his authorities. And then he went on to say, at the beginning, this is still 1960, he said, the purpose of this is to ensure that when our rights as citizens are infringed, no parliament can do so except in the open, not inadvertently, not by concealment from Parliament or the country. Section 4.1 of the Department of Justice Act, I'm going to zip along here, it essentially is the same as the provision we just looked at in its final form, except that it refers to the Charter. So it was enacted after the Charter came into force, and it refers to a similar examination. All the provisions are essentially identical. There is one small difference in the French version. One of the verbs, I think, is slightly different. I think the French version in the Bill of Rights says something, the purpose being to vérifier, no, rechercher. In the 1960 Act, it's rechercher si il y a une incompatibilité quelconque or something like that. And in the 1985 Act, for some reason, they chose, instead of rechercher, vérifier. But otherwise, they're identical in both languages. What did Minister John Crosbie, who was the minister who introduced this provision, have to say? He said, well, these amendments provide a similar obligation on the Minister of Justice to examine bills to ensure that they are consistent with the Charter. He didn't say to ensure that they had a faint hope of consistency or that they were not hopelessly illegal. He said that they were to ensure that they are consistent. These are the other provisions referring to an examination that are at issue. Unlike the first two, which are examinations assigned, the duty is assigned to the Minister of Justice, this is a duty assigned to the Deputy Minister of Justice, and it's expressly stated to be intended, the purpose of that examination is to ensure that, remember that's the old wording of the Bill of Rights that was replaced with to ascertain whether there's an inconsistency. This remained as, or became, to ensure that A, the regulation is authorized, and C, it isn't inconsistent with the Charter and the Bill of Rights. Okay. What did Minister John Turner have to say about it? I think I've already covered that with you, and I'd like to skip ahead. So, that's the legislative context in which I found myself when I was asked to do these examinations. What happened was that I was told, well, okay, let me back up. I read the provisions and I decided that, well, what they required me to do was look at the provisions and form an opinion. Do I believe these provisions are A, consistent with the Charter and the Bill of Rights, or B, not consistent? And I would have to reach one conclusion or the other. And I was told by my colleagues and supervisors in the department, oh, no, that's not what we do. Well, I said, what do we do? Well, they said, we ask ourselves whether there's a credible argument. I said, well, what exactly do you mean by a credible argument? Well, an argument that can be made. You know, and when you began to push that a little bit further, it began to sound more and more like they meant an argument you could make without being utterly shamefaced in front of the court. And I thought, well, that can't be. But in fact, you'll see from this that it is exactly what was meant. Here are the most recent instructions, or some of the most recent instructions given to us as counsel in the department, that were made public in the action that I'm telling you about, the one that resulted when I sued my minister and deputy minister. They were made public in that action only after I asked the court to take them into evidence. And at first, of course, the minister responded, well, I shouldn't say of course. At first, the Attorney General responded and said, oh no, this is all privileged. This is confidential. In fact, the minister, the Attorney General, sought to strike out the claim utterly, to delete the paragraphs that referred to this standard of review, to stay the action. All of these were alternate forms of relief sought. Eventually, the Attorney General abandoned them and agreed to file these documents in redacted form with the court in a public way. In other words, not in a sealed file, but accessible to the public. So what I am giving to you here now are documents made public by the Attorney General. I'm not revealing any secrets that I only know of or anything like that. Please be assured of that. These are public documents. Okay. You saw the 5 ranges there, right? Each 20% wide. Well, here's a description. Well, let's just go back there for a second. So it's recommended that the following scale be used when assessing the likelihood that a legal challenge to a particular initiative or measure, including a legislative measure, will be successful. And those were very low, low, medium, high, and very high. And let's look at the wording that's used to describe high and very high. This connotes the probable invalidity of the measure. Very high, the likelihood of a successful challenge is almost certain. And then all of a sudden there's something that doesn't show up in this slide at all. But think of it as a little red zone here somewhere. And where exactly is it? It's at the far end of the 5th range. So 81 to 100%. Well, what's the far end of an 81 to 100% band? Is the far end of that band 100%? Well, probably it would mean a little, it would go a little further than that. So maybe 99%, maybe 98%, maybe even 97%. But by the time you're at 95, do we commonly refer to the final quarter of a distance as the far end of it? Probably not. So most likely, the ordinary meaning you'd attribute to that sort of expression would be something in the high 90s percentile, right? That was the way I read it. I think that's a reasonable reading of it. So this is the standard that the department referred to as the credible argument. Now, it's true that credible, one meaning of it is capable of being believed. And that is the sense in which they used it. I mean, if there's a 2% possibility, then it is clearly capable of being accepted or believed. But we also sometimes use the word credible in the sense of likely to be believed. And that is not the sense in which the department was using it. And I think that's a very common misunderstanding. And I think they wanted to, if I were to be blunt, I think they wanted to use that language of credible argument as a way of concealing, in essence, how low their standard really was. I don't want to use that language because I think it's misleading. I think this is more accurately described as either the faint hope standard or perhaps the hopelessly illegal standard. You report when it's hopelessly illegal, not even one argument to be made in favor of it. And that's the only time you report. All right, well, what did I do? It's not fun to find yourself at odds with your own colleagues. many of these were people I admired and respected, had fun working with. What do you do? Well, the first thing I did was, let me think about this a little more. So I began thinking about these provisions and asking myself, well, how does one interpret them? What would be the arguments that would be relevant to how one would understand these provisions? I researched and studied the issue. I did the work of going to the parliamentary record and finding out, well, what did the ministers of justice say when these were introduced? Is there any evidence as to what the department thought they meant earlier in its history, etc.? I raised the issue in discussions with my colleagues and in memoranda to my supervisors and colleagues. And indeed, there was some unease, I think, it would be fair to say, about the standard. But in the end, nothing was done. And along the way, I was warned I ought not to continue to raise this issue too much because my possibilities for promotion and for senior roles and management roles would be jeopardized by that. Lest you think I am some sort of hero, I have to say to you that that did result in me toning back my comments. I was a pretty human person. I wanted those promotions. I continued to make my comments, but I did not make them as forcefully, perhaps, as I might have made otherwise. I delayed in raising it up to the deputy minister's level because, quite frankly, I too was in sort of the middle or early part of my career. And you are incredibly vulnerable at times. So, that's what I did. I also considered my ethical obligations under the Code of Professional Conduct. It happened to coincide, to some extent, this whole experience with the adoption of a new code by the Law Society of Manitoba. And they required lawyers who were part of the Manitoba Bar to take a 2-hour training session on the new code. In that session, one of my former colleagues, Doug Bedford, spent a fair bit of time on these provisions. And I found it fascinating. He said, look what the code says. Remember, when you act for an organization, it's the organization that's your client, not the particular individual or officer or manager or whoever that is communicating with you on behalf of the corporation. And sometimes there might be a discrepancy between these two. And you have to be alert to that as a lawyer because you are acting for the organization, which is distinct from its shareholders, officers, directors, employees, etc. There was a further rule that he brought to our attention. When your client is an organization and proposes to do something criminally or illegally, and illegally really includes, I think, the broad sense of unlawfully. It doesn't have to be criminal. It's just not lawful. What do you have to do? Well, the essence of this, and I need to move on here so that we leave some room for discussion, the essence of this is you have to raise it. You have to raise it with the persons who have given these unlawful instructions. You have to raise it with their supervisors. You have to raise it up the organizational chain of your organization until you have reached the end of that process. And then, according to this, you may need to withdraw from acting in the matter. If they really will not act in accordance with law, you may even need to withdraw. I'm not going to go into all the details or niceties. There's just too much to cover to carry on with that. So how did I come to the decision to commence an action? I had exhausted all levels except the deputy minister himself by 2012. And then in 2012, I said, well, he's the CEO of my particular organization, at least in a way. There is that ambiguity within a government department, whether is the deputy minister your CEO is or is the minister. And there is this kind of division between the administration and the executive officers. And I wasn't sure how to sort that one out, and I decided that my responsibilities with respect to that ended at the deputy minister, because practically speaking, the minister would take the advice of the deputy on this issue. But who knows? That can be open to debate. When the deputy minister refused to take any action, I consulted the public sector, what's the act? I think it's called the Public Service Conflict of Interest or something, not conflict of interest, Wrongdoing Disclosure Act or something like that. The name isn't quite the same as the officer's name. The officer appointed under that act is the Public Sector Integrity Commissioner. So I consulted that office. I said to them, you know, here's the issue. Here's the difficulty. The legislation says X. I'm getting instructions that, to me, seem to say Y, where Y is not equal to X. And I'd like to know, you know, this needs to be resolved in some way. And I think it affects the interest of Parliament, because, after all, the report under the two of these provisions was to be made to the House of Commons. So you, as an officer of Parliament, have an interest in this. So why don't you fund an independent legal opinion? Why don't we get an expert in statutory interpretation to give us his or her take on what these provisions require? And the Public Sector Integrity Commissioner responded saying, well, I don't really think that this is something that's important enough for me to investigate. I wouldn't be likely to investigate it if it were reported as a wrongdoing, and therefore I certainly won't fund even $3,000 of funds toward a legal opinion. To me, that I have to say, that strikes me as just ludicrous, absolutely ludicrous. But that's the decision that he made. As a result, I had to decide what else to do. What were my options? To go to the press, to go to Parliament, to go to court. Those were really what I thought of as the principal options. And it seemed to me that in this case, the right answer, the best answer, maybe is the better way of saying it, was to go to the state's own body assigned to adjudicate these sorts of questions. The courts are an arm of the state. And since I was receiving state instructions and was a state employee, I should have recourse to the state institution whose role it is to resolve issues of this sort. So that's why I commenced an action. Okay, I won't spend time on this because we need to move on. I'm basically asking for declaratory relief. Let's say it as simple as that. I'm not asking for any remedies that have to do with damages or anything else at all. I'm asking the court to say, tell us what the law requires. Okay. Tomorrow, at the symposium, I want to speak a little bit about some of these ethical related questions. I don't have time for that today. So today, I wanted to talk a little bit about what's legislative interpretation got to do with it, and how does one do it? And what I want to begin with is saying that, well, the state is an organization that acts through texts. That's one of the principal ways the state acts. It adopts a constitution, a text. It enacts statutes, texts. It enacts regulations, texts. So that is one of the principal ways in which the state as an organization takes decisions and acts. So to know what the state has decided, you have to consult the text and you have to come to an understanding of it. So there's a process of extracting a meaning and applying that meaning that has to take place inevitably with all of these texts. Who has to engage in this process? Well, First of all, the state administration. If you're part of the federal public administration and there's an act that tells you to do something, you have to decide, well, what does that mean? What do I actually have to do? That was me. I was supposed to be carrying out these examinations. So I had to ask myself, what does that mean? What am I to do? I don't know whether you've come across the Carl-Tona doctrine in your studies. I think you're still early on in your studies at the faculty here, but you'll come across a decision and a doctrine that's referred to as the Carl-Tona doctrine, which basically says, well, when Parliament assigns a duty to a minister, Parliament never expects or intends the minister is going to do all of these things personally. It expects that the federal public administration, in the case of a federal act, will act in the minister's name to carry out those duties. And that's what I was doing. I was acting in the minister's name to carry out these examinations which had been prescribed by Parliament. So a person in the state administration needs to come to an understanding of a legislative text often in order to implement it. Individual citizens often need to understand texts to know their rights and freedoms and obligations. Legal advisors need to understand texts to see what advice to give to their clients. Courts, judges need to sort this out in deciding conflicts that come to them. So all sorts of actors need to engage in legislative interpretation. The sentence that is oft quoted by Canadian courts as summarizing the interpretive task is this one. Today there's only one principle or approach, namely the words of an act are to be read in their entire context, in their grammatical and ordinary sense, harmoniously with the scheme of the act, the object of the act, and the intention of Parliament. I want to extract from that essentially three key things. Text, so the words of an act in their grammatical and ordinary sense. Context, and it specifically refers to entire context, we'll come to that, and purposes and consequences. So, a question. Why do you begin with the text? There's been this long-standing dispute about, literalism and plain meaning and all sorts of different language used to describe it. But somehow there's always been this tendency to give the words, the text itself, some primacy, some first importance. Well, why is that? I suggest it's for a very practical democratic process reason. What is it that gets put before Parliament? It's a text. It's a particular text. The members of Parliament, in assessing whether they want to vote in favor of that text, have to ask themselves, well, what do we think this text means? They're not asking some question about, in general, what's the government hoping to do? That's relevant too, but what they are being asked to enact is a text. When they consider it in committee, they consider each provision. And what's the debate about? Do we want to adopt this text, or do we want to amend this text in some way, or do we want to refuse this text in some way? People in the public who see what is being proposed in Parliament, their discussions have to be founded on the text. They have to look at the text and say, well, am I content with what is being proposed, or do I want to write to my member of Parliament saying, no, I would like you to oppose this or amend it because I think the text is inadequate. So the whole democratic process relies on a text. Now I'm not trying to say that means that a new kind of literalism. I'm just saying I think it's appropriate to give the text some primacy because that is how the democratic process works. Now, what about context? Con coming from the Latin root meaning something about together with, accompanied by. Well, there's a whole lot of context, and Dreger's little sentence talked about the entire context. So other texts, the rest of the act, other acts on the same subject, the whole of the of the body of statute law, all of that can be relevant to understanding what this one particular text means. The setting. What people are we talking about? What is your culture? What sorts of assumptions are you making in reading this text or writing it? And will that affect the likely meaning of it? The story. How did it come to be? What situation was it responding to? Economically, social structures, mores, religion, law, international affairs, all of these contextual facts can, at times, affect the meaning of a text. So, for example, the Bill of Rights. Historically, it followed not long after the adoption of the International Declaration of Human Rights. It followed in Canada, where, in fact, one of the Canadian scholars, a professor at the University of Montreal, I believe it was one of the principal authors of that Universal Declaration of Human Rights. So, historical context is relevant. I'm sure that John Diefenbaker knew about the Universal Declaration of Human Rights, and it affected his desire to do this. Okay. So, purposes and consequences, I'll just say that any organization, it's my submission to you, my thesis for you to think about. I think organizations are inherently purposive. You do something together because you want to accomplish something. Therefore, anytime the organization acts, it's appropriate to think about whether the consequences, whether what it will do, first of all, what it intends to accomplish, and secondly, will it accomplish what it intends to with the meaning that I am going to be attributing to it. All right, so I was going at this point to go to the document in which I have sort of put together a whole lot of statutory interpretation arguments related to these examination provisions. I found out earlier today that you've actually already had a chance to look at that document, and so you'll have had a chance to sort of sort through some statutory interpretation arguments in this particular context, so I don't think we need to do that. So what I'd like to do instead is start with a question to you and then allow time for discussion. And my question to you is this. In the history, the legislative history of the 1960 provision, do you recall anything in its legislative history that would suggest to you an argument against the Department of Justice's interpretation of that provision? Anything in its legislative history that would suggest to you maybe the meaning they're giving to it is not what was intended? Do you remember what the original wording was? Yes. Yes. Do you think it's likely that the bill would have been amended, rephrased to move from ensuring, which is guaranteeing the result of consistency, to almost no standard at all? It's such a long gap. Wouldn't it be more likely to think that Parliament intended to nuance their earlier thought rather than to reverse it utterly? Okay, thank you. Good point. Now, your questions, your discussion, your thoughts.
I know there were some interesting questions asked from the group of legal methods I was teaching on Friday, and I bet you'd get way better answers if you had a chance to ask Mr. Schmidt.
Yeah, I'm just curious about the scale that's used by the
Anytime you're trying to decide on the constitutionality of a piece of legislation, it is a judgment. It's not a mathematical calculation. And that's what the work of lawyers mostly is. It's forming judgments. and forming opinions and communicating them to others. So it's not that the scale is where you start. You start with the text, you start with the law, you start with the jurisprudence, and you say, okay, and the consequences, incidentally, are very important. You start with facts and with law, and you say, okay, when I consider everything that's relevant, do I think that this legislation is consistent with the Constitution, the Charter, or not? And then the scale sort of is a way of trying to reflect how strongly you think that. So if you think you're absolutely certain it's consistent, you would choose the first, 0 to 20%. If you thought it was likely consistent, but there were some arguments that could be made that cause you a little unease, you put it in the 20 to 40%. If you think it's pretty much a balance, a wash, it's in the 40 to 60. If you think it tilts the other way, you put it in the 60 to 80. But it's really more an after-the-fact kind of way of, okay, I've formed my opinion. Now, how would I best describe my opinion using these 5 possibilities?
Did they ever, okay, so it appears as if the only time it ever mattered was when it was like 98 to 99%. Why have the scale if they're not going to consider? Did they ever consider, or was all legislation just kind of held to that 98, 99%?
I think of these examinations as a kind of quality control mechanism. And if you think of that in a factory, for example, if you have a quality control process for your products, your gadgets, your manufacturing gadgets, well, if all your gadgets are great, even if you have a defective quality control process, there is, in the end, not a huge problem because all your gadgets were good to start with. What am I trying to say? I'm trying to say, therefore, that the relevance, you always, let me try it again. You always want an effective and functioning quality control mechanism because you never know when some defective product might just all of a sudden be turned out in the factory. And I think it's the same in the Department of Justice with legislation. You want a functioning quality control test because without it, the possibility exists of some defective product being put before Parliament without Parliament being made aware of it. That doesn't mean that there were a lot, and in fact, I'm not commenting on how often it happened or didn't happen. I'm just saying I think you need to have a proper functioning quality control process, and that would be important.
Ed, thank you very much. I'm going to take a minute to ask a question because this is something I often raise with my advanced constitutional law students in my charter seminar. Some of the comparative models of legislative review for Bill of Rights consistency. And I'm sure you know, of course, that Canada was actually, this model was a model for other jurisdictions like the UK, like New Zealand, and other constitutional democracies. Well, democracies that have bills of rights in any event. And in those other contexts, the review is different, right? So, for example, there is a requirement in New Zealand, I believe, or is it in the UK, you probably know, that the minister has to report in any event about the constitutionality, about the consistency of the law with their Bill of Rights. So it's not you only report when there is an inconsistency, you actually report in every case and say why and how it is consistent. I'm just wondering what you think about a model like that would require a report in every case, and whether you think that might be better, or what you think the merits of that would be.
I think it's the UK that you're talking about. I think in New Zealand it's a similar standard about reporting where there's a problem, but there the Attorney General has reported many times. And sometimes Parliament has disagreed with the Minister, which they're free to do. The UK requires a report of consistency, or a report that the Minister believes it's not consistent with European human rights, but why then a justification. Would that be a better approach? Well, I think that the approach taken in Canada actually has essentially the same result if it's properly understood. But if it were worded the other way, it would not be capable of the misunderstanding that I think the department has taken, the inappropriate understanding they have developed of the Canadian provisions. If it said, you must report, and your report must be either A, that it is consistent with the Bill of Rights, or B, that you think it is not consistent and why you are proceeding with it in any case, I think it would be clearer.
Yeah, my question is somewhat similar to that in that obviously provinces are subject to the Charter of Rights and Freedoms and their laws have to probably be consistent. Did you find in your research, some comparisons made between provincial standards and federal standards when it came to interpreting the Charter?
There are no similar provisions in the provinces that I'm aware of that require by statute a similar examination. But of course, every province has its justice officials looking at proposed legislation to consider the constitutionality of it and to advise. So that is, in fact, happening all the time. And all I can say is I didn't research it at the time, but I not long ago had the occasion to give a presentation at the New Brunswick Bar Association midwinter. And a former Attorney General and certain legal counsel whose job it was to do similar non-statutorily required examinations there commented that they certainly did not use a faint hope or hopelessly illegal standard. So I don't think that that standard that the Department of Justice federally uses is the one that is applied in most provinces.
Did anybody of your colleagues feel that you were doing the right thing and offer to help, or were you a lone horse in this?
First of all, there were colleagues who saw things the same way. Some of them, many of them, for very good, the same reasons that motivated me to perhaps dial back things for a while, were still in very vulnerable times in their careers. Others just disagreed and some didn't care. So it varied. I can say that a fair number of my retired colleagues have been very supportive. So once the risk of reprisal was not there and they could just form an opinion, many of them have been very supportive. And in fairness to my colleagues or former colleagues who continue to work for the department, Ottawa's a small town. I'd be downtown in Ottawa on some business and I'd see one of my former colleagues. They would make a point of crossing the street to greet me, to say hello and wish me well. And I think that's an indication that within the Department of Justice there's actually tremendous unease with this standard. And I can't see why there wouldn't be. I think there are many people within the Department of Justice who, in their own opinion, see this as really abominable, quite frankly.
I'm curious about the reasons behind why would a ministry not try to be on the right side on looking at the constitutionality of the wording that is going to be enacted? Why would they not listen to what you and others may have to say? You may call me naive, but I just can't really picture like what's going on.
I think there are a couple of things I should say. First of all, let's distinguish between a report to Parliament and advice given internally within the administration and to the executive officers of the state. Just because the department was not telling their minister that he needed to report to Parliament didn't mean that they weren't telling their colleagues and people inside the public service and inside the government that there were problems with legislation. So I do think that those sorts of things got communicated. why did they consider Parliament to be less important? And I think that the answer to your question partly lies in what I think is a profoundly inadequate understanding of the state that prevails in many ways in the public service and in the government itself. It's illustrated, for example, by a very sloppy linguistic usage. Have you ever seen a sign that says this project was funded by the government of Manitoba or the government of Canada? Think about that a little further. Whose money are they using in this project? Is it the government's? Of course not. The government is essentially the executive officers of the state. It's the state's money. It's Canadian money or Manitoban money that they're using. And I think that same conceptual inadequacy has infected the thinking of the Department of Justice so that they don't understand that they are public servants, that they are servants employed by the Canadian state, that their employer is the Canadian state, that their duty is owed to the Canadian state, that these ministers that provide instructions to them are entitled to respect and their support and assistance just as any other officer of an organization is entitled to the support of the staff of that organization, but not when what they propose to do goes contrary to the decisions of the organization itself. And the Charter is not some foreign document. It is the document adopted by the Canadian state as its part of its fundamental document. So persons who act in the state, in my view, and you can tell I feel about this quite strongly, people who are in the state structure, in my view, owe a duty as officers or employees to act in accordance with those decisions. So the Charter is not some foreign document that the minister can disregard and take a risk with. It's a document that he or she has a duty, in my view, to implement. And that understanding, I think, is very deficient in the public service and in the, quite frankly, in the government.
Well, a very strong way to finish, and I'm keeping an eye on the time. I do want to invite my my colleagues and the students and staff here to thank you. But before I do, let me just give you a small token of our thanks here, the coveted Robson Hall coffee mug, and just say that I don't know if you noticed when you came down the escalator at the airports. There's actually a photo of my colleague Karen. It must be a very large photo. But there's the University of Manitoba has a motto, a slogan around trailblazers, defenders, folks who it's based on this idea from here you can go anywhere and do anything. And I guess your talk today and what you're engaged in right now certainly would characterize you as a trailblazer, I think, and a defender. And we want to thank you for that, what you're doing and how you're representing Robson Hall out there in the world. Thank you.
Thank you for those kind words, Deborah.